Money launderers are marked by an essential characteristic. One does not suffer from a lack of money, but from an excess of money. Since only those Wirecard customers who took out a loan had to be forwarded to the bank, money launderers remained in the group. There they were protected from the anti-money laundering system that is mandatory for a bank. Regarding that, I write to the investigative committee of the German parliament. Ordinary money laundering prevention systems only know the relationship customer, account, business. As explained in the previous chapter, accounts first had to be formed from invoices. The bank therefore had to be supplied with the transactions at the same time. This can lead to runtime problems and thus easily to confusion in the databases. While there was no mandatory money laundering prevention in the group, it was difficult even for the bank to implement it effectively. Lately, I also described how the company's maxim of not giving the impression of being a bank or being subject to supervision prevailed when it comes to supervisory authorities. The goal was to create a sharp separation, while at the same time working on the same IT systems between the bank and the group. Regarding that, I told the investigative committee of the German parliament. Structurally, however, the problems in combating money laundering began much earlier. Strict KYC, know your customer, regulations apply to banks. In case of an online bank, this customer identification, this is usually known as the German Postident processings. However, these regulations did not apply to the group as being a non-bank. Of course, there was always the intention to correctly identify one's customers. On the other hand, in this case, too, the aim was to avoid building up processes in the group that could arouse the suspicion that one behaves like a bank, so the BaFin declares one to being a bank. The investigative committee of the German parliament received the following information on this circumstance. After the preliminary report of the investigative committee of the German parliament was published, I was particularly interested in the part about money laundering. In doing so, I noticed that the responsible authorities had obviously only scratched the surface or were looking at the wrong place. That seemed like an alibi event to me, especially the absurd proportions it has taken on. My attention fell on the following. With reference to this section, I asked the German Federal Attorney Association on August 7, 2021, whether it should not be in their business interest to deal with legal misconduct by non-chambered lawyers. The chamber got asked to provide information on how many cases of money laundering it has become aware of on non-chambered lawyers. On August 12, 2021, the chamber informed by email. We also inform you that non-registered lawyers are not registered with any attorney association either, so that such complaints will not be available there either. If the Federal Attorney Association would consider money laundering among non-registered lawyers to be a relevant problem, it would be closely monitoring it for sure. Since, according to the report of the Lower Bavarian government's investigative committee, the non-registered lawyers fall under the audit of financial companies, one must also ask oneself at this point whether the issue of money laundering is actually taken seriously. I have previously described how Wirecard's business model was predestined for certain types of money laundering and how the BaFin gave Wirecard a wide berth. The failure of the BaFin in the Wirecard case, and in particular in money laundering, thereby is confirmed in the report of the investigative committee of the German parliament. According to the email from the witness Mulzer on May 20, 2020, which says, "Unfortunately, despite repeated inquiries, it has not been possible to coordinate with BaFin on this, as these have always remained unanswered. And, as already communicated by telephone, Bavaria has not yet issued a general decree for the appointment of a money laundering officer pursuant to Section 7-3 GUPG. The BaFin has its own department for money laundering, where my reference is kept with a file number. In the case of fundamental questions, however, these are passed on to the management level and made, taking legal assessments into account. If no answer is provided, this has to be taken as a refusal. It is therefore obvious that the BaFin was aware of the problem of money laundering at Wirecard. The report of the Bundestag Investigation Committee names my former colleague Marcus K., the bank's money laundering officer, a total of 11 times. On June 28, 2021, we made a phone call, because the minutes of the Bundestag Investigative Committee mentioned that there was a meeting with Mr. Waldemar Kindler. In general, if you are introduced to someone in your field for the purpose of working together, it is common to find out what level of knowledge and qualifications someone has in the exchange. Marcus confirmed to me that this also happened, and he had to realize that Waldemar Kindler had no idea about money laundering prevention, neither about black and white lists, embargoes, or even pattern recognition. After I filed a criminal complaint against unknown persons on January 28, 2021 for money laundering and against the board members of Wirecard for aiding and abetting money laundering, the Munich Public Prosecutor's Office was informed in my letter dated March 15, 2021, under file number 402 AR 1947/21, by naming the group of persons involved in the money laundering and got asked to grant access to Wirecard's business data. This letter remained unanswered. On June 26, 2021, I am writing to the Bavarian Interior Minister, Mr. Hermann. Dear Minister Hermann, as a whistleblower to the Third Investigative Committee of the German Parliament, I provided them the enclosed dossier I had prepared on the failure of the BaFin in the Wirecard case. In it I describe, among other things, how money laundering took place at Wirecard. As can be seen from the report of the Investigative Committee of the German Parliament, the Bavarian authorities have either not carried out any or no complete investigations into the Wirecard case. It has already become public knowledge that the former Bavarian police chief, Mr. Waldemar Kindler, acted as a lobbyist, in contrast to this formal assignment to advise on the prevention of money laundering. It can be gathered from Mr. Kindler's professional career that he does not have the analytical skills to uncover money laundering. By that I have a lot of questions for Mr. Kindler. As a former superior, I would ask you to comment on the allegations, and since I do not know Mr. Kindler's address, to forward my questions. The letter remained unanswered. On September 19, 2021, I prompted the Bavarian Prime Minister to step down from office for the first time, with reference to my petition 954/21 to the European Parliament and the lack of a response from the Bavarian Ministry of the Interior. Only then did the Bavarian Ministry of the Interior reply on November 3, 2021 under file number C5142 to 73088 KOP. Referring to your letter dated September 19, 2021, you contacted the Bavarian State Chancellery and requested the resignation of Prime Minister Volker Bouffier and Mr. Prime Minister Dr. Markus Söder. The investigations of the Munich Public Prosecutor's Office are still ongoing. Further information can therefore not be given. We ask for your understanding for this. As shown in this and the previous episode, the Investigative Committee of the German Parliament was extensively informed by me on money laundering at Wirecard, but its report only scratched the surface. At the same time, the report shows how authorities have systematically avoided efforts to throw light on that. This is substantiated by the denial of the fax receipt of my criminal complaint to the Munich Public Prosecutor on March 8, 2021. The member of the Investigative Committee of the German Parliament, Fabio De Masi, reported on July 20, 2023, to Wirtschaftswoche. I think it's conceivable that money was laundered via Wirecard. This raises the question of how it is that he didn't notice this earlier. After all, his office answered the following when my dossier was made available to him on November 19, 2020. Your dossier is very interesting. Thank you very much for that, and also for your offer to be ready for an exchange in matters of financial supervision/BaFin. In the end, there were no queries. When considering the report of the Investigative Committee of the German Parliament, one has to adjust one's perspective on the report, considering the aforementioned circumstances. It is not necessary to look at what the report reveals. Rather, one must look at what the report does not reveal. Nothing is said about what concrete measures were taken to combat money laundering, what successes have been achieved with them. It is also not reported which transactions at Wirecard were considered by the authorities and which measures were taken. On the other hand, based on my hints, the committee could have searched on the right place, but did not do so. Instead, they just watched.